Constitution envisage a situation where an acting governor will be acting, and I mean, for how long? In this case, for instance.
Yes, the express letters of the Constitution did not say how long. The express letters of the Constitution could as well mean 4 years. Now, but the spirit of the Constitution envisages like 3 to 6 months. And that was why the amendment that was made, because the essence of the National Assembly moving that there should be amendment to that session. Remember the Yaradua imbroglio, when they said, look, whether you transmit a letter or not, within a specific number of days, somebody should make an acting president and acting governor. Now, remember, like what I said, once they have done that, they have kickstarted a process. And like I said, if I were the acting governor, in the interest of the state, not in my interest, if I were the acting governor, since I have all 100% of the powers of the, because once you become an acting governor, the powers of the holder of that office is suspended, is technically suspended. 100% suspended until he comes back. If you look at the American Constitution, what it says is that the deputy is the person to transmit when he has the confidence of the majority of the members of the EXCO, not 2/3. Our own is 2/3. He says the acting person, when he has, or when the governor is not available or the president is not available in America, the person in the, that is the deputy governor or the vice president, if he has the consent of majority, he can transmit that letter. He can transmit that letter to the assembly. Now, if also the governor or the president is sick, for instance, in America, the same vice president too, when he is sick, if he considers that the president can no longer act, maybe either because of infirmity of mind, can also transmit the same in the presence of the president. But the president can as well countermand it by also transmitting back to the assembly that I am fit and proper. So it is now for the assembly to look out to find out whether the president is actually fit and proper. So why can't we, if we are copying from America, why should we copy it in such a way that it will be detrimental to our system, knowing the type of people we are, knowing the type of people that have seized power for a long time?
In other words, it would seem that in the American Constitution, the powers doesn't lie with those loyal to, supposedly loyal to, say, the person at the helm of affairs. It could be someone on the outside, for instance, the deputy. But the deputy is not exactly someone on the outside, but at that particular point in time, it would seem when the deputy is already thinking of maybe appointing new commissioners or ministers, that person seems like someone on the outside.
Yes, the deputy, when you look at it in a way, though chosen by the governor before and because of political exigencies or expediency too. Now, but in this context, he has become somebody outside. But the American Constitution says when he has majority, that means majority is 50% plus 1. But in Nigeria, it's 2/3, and you can never get 2/3. But my own proposition is that if you have the interest of the state, as acting governor, you simply need to liaise with the assembly. Sack, if the executive do not want to do it, sack them, appoint new ones, and they will do it.
It doesn't look like anti-party activity or being disloyal.
That is also another issue, the issue of party. You also a member of that party. Remember, this is not an opposition. And you are going to also appoint commissioners based on input from the party. So there is no way I see it as anti-party activities.
Let's look at the deputy governor in the Constitution. Yes. Where does his allegiance lie? To the governor or to the people? Because every time we get to hear my boss. I also remember then when we had the issue between former President Obasanjo and Vice President Atiku Abubakar, then you get statements like disloyal to your boss. Where does their allegiance stand when it comes to a vice and a deputy first?
Yes, when you look at the Oaths Law, or the Oaths Act in the case of the Federation, the allegiance of the vice president lies to the Constitution. That is, lies to the people through the Constitution. What he did not swear to obey the president or to serve the president, he is saying, I'm going to serve the people by obeying the tenets of the laws governing the land. The same thing with the deputy governor. The same thing with the National Assembly. The same thing with the judiciary. The same thing with all the actors, including members of the executive. That is the commissioners, the ministers, all of them. Their allegiance is not to the president. But what do we see?
So if we have an assembly, national or state, that has refused categorically to come forward and constitute a medical panel, and publicly we get to hear statement, verifiable ones, maybe from the hospital where maybe an alien public officer like a governor or president is being taken care of, and statements that will definitely show that this person is permanently incapacitated. Can the assembly then act on that?
You see, just like we said, following the law, the executive will transmit to the assembly. It's only that time that their powers will start. Their powers cannot start, otherwise there will be confusion. But you know, when these things were framed, they were framed bearing in mind that it's just like what happened in Anambra State that time. You know, that time P2B was purportedly impeached. The assembly, if you base it on majority, the assembly could have said, oh, the man has infirmity of mind. And they will go and get some 4 medical doctors and pay them, and the 4 medical doctors will declare him insane. That's what would have happened. And he's gone. So that is why the Constitution puts those roadblocks.
Okay, by also bringing the
By
personal
also
physician
bringing the personal
of the
physician, and also by making sure that it starts from the executive. So that it's not when you buy the entire members of the House of Assembly and you cannot see him in acts of corruption, you now go into medical. So that is why he said also, personal physician. So you see the roadblocks. The first roadblock is that it's members of his executive. The second roadblock is that there should be his personal physician in the team. These are meant to curb some of the things we would do.
But if the views of the commissioner could pass for those of the thinking of the executive in Taraba State, where they say is that, look, we've got an acting governor, all seems to be well. We shouldn't bat an eyelid over making a mountain out of a molehill, as they put it. You think that theory should stand?
If you are an acting governor for 1 year or so, or getting to 1 year, you do not necessarily have a plan. But when you are a substantive governor, when you are becoming a substantive governor, you can now have a plan. And then you now have people who will listen to you, who are loyal to you. What I mean by loyalty in question, that is, who will not question your authority. I'll give you an example. When President Jonathan was an acting president, sometimes we had some of these things that he will ask the minister to do this. He will not do that. Some of the ministers were approving things without referring it to the executive council. So, but if he is a substantive, like immediately he became a substantive president, it became very easy. The loyalty to the constitution through the president is there.
All right. Chukwuma Ezeala is a legal practitioner. Thank you for coming on today.
Thank you very much.